Enga mana, enga reo, enga rangatira, onge hoe wha, tēnā koutou katoa. My name is Bryony James. I'm the Provost here at Te Harangawoka, Victoria University of Wellington, and it is my very great pleasure to welcome you all to the 2026 Sir Owen Woodhouse Memorial Lecture. It's my great pleasure to welcome our distinguished guests, and in particular, where have they gone? The Woodhouse family are here representing. Several, yes. Thank you so much. We are genuinely grateful for your ongoing support and delighted and honoured to have you here. This memorial lecture commemorates the life of the distinguished Judge Sir Owen Woodhouse. Sir Owen made an immense contribution to New Zealand law and society. He was known for his compassion, his generosity of spirit, and his social conscience. This was reflected in his work as President of the Court of Appeal, President of the Law Commission, and Chairman of the Royal Commission on Compensation for Injury that recommended a no-fault accident compensation scheme that laid the foundations of ACC. And that latter point is the strong nexus with our speaker tonight. I'm delighted to welcome Professor Michelle Mello to give this year's Woodhouse Memorial Lecture. Professor Mello is both Professor of Law and Professor of Health Policy at Stanford University and is a global authority on medical liability and public health law. She's widely published across a variety of topics related to health and the law, with recent topical articles on vaccine recommendations and on the use of artificial intelligence in healthcare. In 2013, she was elected to the National Academy of Medicine, one of the highest honours in the field of medicine, and, as I'm sure you can imagine, is frequently sought out to provide advice to Congress and government agencies, serve on expert panels, give keynote addresses, and, of course, memorial lectures. This evening's lecture and location is a return to Aotearoa for Professor Mello, who spent 2 months here back in 2006, studying the ACC system to take lessons back to the United States to inform medical liability reform efforts. In this evening's lecture, Professor Mello will explore developments in New Zealand's ACC cover for medical treatment injury, alongside developments in injury compensation in the US. She will examine how the two systems have balanced the needs of patients, healthcare providers, and the wider system. And she will discuss what we have learned 2 decades after New Zealand's shift from medical misadventure to treatment injury. Coincidentally, I attended Professor Graham Austin's second-year torts lecture last week, where he discussed treatment injuries and ACC. So even though I am none the wiser, I am better informed, and will be better informed again after this evening as Professor Mello brings her unparalleled insight to this timely conversation. Please join me in giving a warm welcome to Professor Mello.
Thank you so much for that kind introduction. And let me begin also with a note of thanks to the Woodhouse family for bringing me across the ocean to speak with you. I'm very grateful to be back. I also want to begin with a note of humility. It is daunting to be asked to come here and present on your own system in front of a room full of people. Many of you spent your lives studying or working in various parts of the system. So I beg your forgiveness and correction of any errors, and I'll leave enough time at the end of the discussion today for you all to tell me how wrong I am. Let me open today's remarks with a story from a study that I did with another Kiwi, Professor Jen Schulz, who's now across at the University of New South Wales, study of patients' experiences after medical injury in the United States and also in New Zealand. I want to talk about a girl named Amerlee, 14-year-old girl who was admitted to the emergency department of a major teaching hospital in the United States with labored breathing. Juliana, her mother, who accompanied her, had actually been employed as a physician at the hospital for more than 2 decades. I'll use their words. Amerlee. It started with my severe allergies. I reacted one night. It was the first time I ever had to use an EpiPen, and I reacted to what we found out was tomatoes. Juliana. The resident verbally ordered epinephrine in the right dose and the right administration. He said 0.3 milligrams, IM, intramuscular. Completely correct. It went downhill from there. Amerly. It came up in the computer as 3.0 milligrams instead of 0.3. So that went through, and then the vial came up with the 3 milligrams, and instead of giving it to me IM, they gave it through IV. Juliana. I was looking at the nurse, and I'd forgotten all about even the IM versus IV part. We were both at about hip level on either side of Amerly. I couldn't quite see, because of blankets, that she was doing it IV instead of into the leg. I was saying to myself, something's wrong, it doesn't look right. It looks like too much, I should push it out of her hand. And all this is in an instant. I should push it out of her hand. No, then they'll make me leave. That took me like 3 or 4 seconds to think that, and then it was too late. I looked up at Amerly. She had turned this weird color of white. Her eyes glazed over. A code immediately began. It was the worst code I'd ever seen. Although she was revived, she then went into fulminant pulmonary edema just a few minutes later and was in cardiogenic shock for 2 days. They did not think she would survive. Amerly did survive. She was discharged a few days later. Both she and her mother were subsequently diagnosed with post-traumatic stress disorder, for which Amerly was admitted to a psychiatric institution. Over the next several months, Amerly was unable to complete her schoolwork. Most of her hair fell out. Her mother had recurrent nightmares about dead girls. Amerly, I was not okay. For a very long time, I was not. There's still not a single day where I don't think about what happened. It comes up in every part of my life. In interviews, it was clear Amerly and her mother connected their ongoing trauma in part to what happened after this event, and the way that the hospital responded to them in the wake of the injury. First, the hospital mishandled their communication with Juliana, creating a lot of resentment and anger. A few quotations from Juliana tell the story pretty well. Then they began discussions about a possible malpractice lawsuit, but settlement negotiations about compensation quickly broke down. As Juliana explained, years later, Amerly still expressed unresolved feelings and needs in the wake of the event. With regard to her research interview, this is what she had to say. This all occurred in a system that is supposed to be able to hold problem providers and systems to account and deliver justice, and yet it fell short in almost every way it could have. And this story is not unique. In the more than 90 interviews that we did, we heard time after time about patients being let down by the system. And I will add that these interviews were conducted at 3 of the hospitals in the United States that have been heralded for being so progressive in their approach to dealing with injured patients. A family like Amerly's would have been faced with massive medical bills in the United States. Even if they had insurance, it likely would not have been enough to cover their out-of-pocket expenses. Certainly wouldn't cover ongoing psychosocial support that both mother and daughter required. The only way for them to get compensation would have been to file a lawsuit. And there, they would also face lots of challenges. First, in finding an attorney willing to take their case. Then in waiting, typically for years, for the case to be resolved and money to start flowing. Suffering a process that is extremely adversarial, and experiencing almost certainly a severing of their relationship with the hospital that would be permanent. Because of problems like this and cases like this, Americans have long looked to New Zealand as an example of an alternative approach that gets things right. I've spent years, if not decades, talking to policymakers in the United States about how we could benefit from moving to a system that is more like yours, But time and time again, we have come up short in our efforts to reform our own system more than just around the edges. We do have limited patches of no-fault compensation systems in the United States, for example, for vaccine injuries, but even those are heavily contested. I understand, though, no system is perfect, and Kiwis have a lot of questions and even complaints about the system that you have. And questions in particular about whether reforms in 2005 to the ACC might have involved certain trade-offs. And in particular, whether you might have traded away some degree of accountability for mishaps in medicine that are due to error or even negligence. So I want to address this question of what might have been lost in 2005 through the lens of accountability, and in particular, the lens of what accountability means to patients. I want to draw on empirical research, as I've mentioned, with Jennifer Schulz and also with Marie Bismarck, another Kiwi who's now at the University of Melbourne, about patients' needs in these two countries. Collectively, these interviews include over 90 patients, as well as about 40 others who have peripheral roles in the system as attorneys, hospital representatives, insurance representatives, and so on, including some of the folks in this room today. And I'll conclude with a few reflections on where New Zealand has landed and maybe some modest suggestions for strengthening public confidence in the system. But to preview my overall conclusion, I think New Zealand has come as close as anyone ever has to getting things right. Maybe the curmudgeon in me would remind you, though, of the quotation from Sir Winston Churchill about democracy. He said, "Many forms of government have been tried and will be tried in this world of sin and woe. No one pretends that democracy is perfect or all-wise. Indeed, it has been said democracy is the worst form of government, except for all those other forms that have been tried." And that, I think, sums up pretty well my feelings about New Zealand. So I want to begin by describing some of the structural mechanisms here in the United States for ensuring accountability in medicine, again, begging the indulgence of those in the room who know much more about this than I do here. Then I want to talk a little bit about what we learned about patients' needs in the wake of medical injury and what they would like to see the system deliver. And offer up a kind of report card based on research about how the systems do tend to deliver on those promises. So let me begin, as any American tort scholar would, with compensation. And I realize that in New Zealand, the conventional view is that accountability in your system has been severed from compensation. There are two distinct silos that are pursued through different systems. Interestingly, though, I don't know that this necessarily reflects the view of all patients in New Zealand. And I did remember that when we interviewed Maori and Pacifica patients here in New Zealand, they almost uniformly told us that, to the contrary, they view compensation as an integral part of a culturally appropriate apology. One of them said, "The offender should offer money, but less as compensation, more as remorse. It's about restoring relationships." In the US, compensation is very much a part of how patients think about accountability. And there are two elements in our system that really drive that home from a structural perspective. One is that we use a fault standard to determine who pays for medical injury. And the second is that we have private financing of liability insurance, which means essentially the tortfeasor, the wrongdoer, pays the costs of the person who has been injured, albeit through a dilution mechanism, private insurance. So let me talk first about compensation systems. This schematic goes over some of the basic differences. Let me highlight some of the differences in the United States. As I mentioned, we have a fault-based system. To recover money, you have to show that the practitioner deviated from reasonable care or that care that would be rendered by an ordinarily prudent practitioner in similar circumstances. It's a judicial process. If your case goes all the way to trial, it'll generally be heard by a jury, occasionally by a judge at your own election. We hire experts to help sort out the truth through an adversarial process. Those experts are hired and paid by the parties, and they duke it out in court. The available heads of damages are fairly extensive. They include not just the elements that are compensable here in New Zealand, but also non-economic loss, in very rare cases, what we call punitive damages, or sort of punishment damages, But non-economic damages are a routine part of malpractice awards. And unlike ACC, our tort liability system makes the defendant's insurer the primary payer of all the expenses, with a few exceptions. But generally speaking, it's not that the patient's health insurance pays first, for example, and then the tortfeasor pays what's left over. They pay the whole thing. An important thing to note is that having a plaintiff's attorney to represent you as a plaintiff is absolutely essential in this system. It is not possible to navigate the system unrepresented. And plaintiff's attorneys, contrary to maybe the lore of American television, are actually quite selective in the cases that they're willing to bring. And the reason is that they operate on a contingent fee basis. They only get paid if their client recovers money, and then they take between 33 and 40% of the award. And finally, as I mentioned, whereas your system is tax financed, ours is privately paid. Physician or usually their employer, as 80% of our physicians are now employed by an organization, will take out insurance for them and the entity itself. Now, in New Zealand, I understand that accountability generally is thought of as falling to agencies other than ACC. And here I know I will make mistakes in naming all of those that are responsible, but these are just some of the key agencies that have roles preventing injuries, improving patient safety, improving medical quality. Chief among these, and where I'll focus most of my comments today, is the Health and Disability Commissioner, which has a very broad statutory remit, but among its responsibilities are to receive complaints from patients who are unhappy with their care. This is separate from the ACC process. And it can choose, and it has statutory authority to take a variety of actions in response to those complaints, ranging from deciding that no action is needed to bringing the provider before disciplinary tribunals, to making safety-enhancing recommendations to the hospital, to referring the complaint back to the provider to deal with. We don't really have an analog to the HDC in the United States. The closest would be our state licensing boards, but those are much more analogous to your medical council. They're responsible for taking disciplinary action against the physician's licenses. I was talking to a couple of representatives from medical council here and learned that just as in the US, most of the action taken against licenses are for the so-called sex, drug, and rock and roll offenses, not for competence or safety issues. Liability insurers also play a role in safety improvement because they hold the purse strings. They can make their insureds do things, attend continuing education, make concrete improvements to their processes, and so forth. But what strikes me about both of these systems, pulling back a little bit, is that responsibility for keeping healthcare safe is fragmented over so many different agencies and private bodies. They all have overlapping missions, but they have different levers available to pull, different sources of authority and jurisdiction. And that makes for a complicated system. Now let me turn briefly to the role of the 2005 reforms here in New Zealand. As many of you know, prior to these reforms, there was a standard for recovering in the ACC for treatment injury that was largely undefined by statute, called medical misadventure. And over time, it had become defined as falling into two different buckets. If you're a claimant you're injured, you either have to show that you suffered a medical error. The standard for that is essentially identical to how we would define negligence in the United States, or that your treatment was properly delivered, but it constituted a so-called medical mishap because it was quite rare, occurs in less than 1% of that kind of treatment, and very severe, defined as you're on disability for 28 days, you're in the hospital for 14 days, etc. So we have two categories that are fairly restrictive here, particularly the medical mishap category. Those were swept away in 2005 and replaced by a unified standard of treatment injury, which we would characterize as a no-fault standard, a single no-fault standard. And the major governors on the speed of this standard, or limiters, was that you had to prove still that the injury was related to the treatment in a causal way. And you also had to show that it wasn't a so-called ordinary consequence of the treatment or a known complication, for example, or substantially caused by the patient's underlying health conditions. These terms themselves weren't particularly well defined, but have become better defined over time through judicial interpretation and ACC interpretation. So that was the essence of the 2005 Reform, in a nutshell, get rid of fault. Replace it by something that looks like a no-fault standard, albeit with a few asterisks. Why were these reforms wrought? I think legal scholars like Joe Manning and others have characterized them as being motivated by a number of impulses. First and foremost was to remove a sense of stigma and adversarialism in the system so that health professionals would cooperate with patients in filing claims. This concept is stunning to Americans, particularly to Americans doctors, that they would cooperate in their own demise. But the goal here is to remove the sense that this is the end of the world as one knows it and replace it with a sort of bloodless administrative process through which the physician, by participating, is in no way acknowledging that an error was made. That, in turn, was supposed to promote a culture of learning, because one thing we've learned the hard way about the fault standard is that it drives information about errors underground. When it's stigmatized, people will not talk about it, and if they won't talk about it, they won't learn from it. The reforms also, however, broadened eligibility for compensation by removing the requirements of rarity and severity from this medical mishap, essentially opening up the scheme to a much broader range of claimants, and taking away some of the knife's edge problems around this mishap standard. So, for example, if you were in the hospital for 15 days, you could claim, but if it was 13.5 days, you couldn't. Okay, so with this background, let me start to reflect on what these reforms might mean for accountability. And I think a basic place to start there is to offer a definition of accountability. There are many that can be found in the literature, but I have a particular point of view about this, and that is that patients' perspectives should be what drive our conceptualization of accountability for treatment injury, and also our policy design. And we're all patients, to be clear. Some of us have already been injured. Some of us are still waiting to be injured. In the United States, we will have on average 9 surgeries in our lifetimes. And when we're in the hospital, we have a 1 in 25 chance of experiencing a treatment injury. So it's not crazy to think about it as a matter of when, not if. But it's also the case that patients who've been through this and their caregivers and loved ones have a very much stronger sense of what accountability looks like. And so it's their experiences that I want to focus on, again, drawing on these 2 empirical studies. So when we spoke with patients and family members about what they wanted in the wake of medical injury, what would make them feel like the hospital had taken responsibility for what had happened, the messages were remarkably consistent, both within each national sample and across nations, which is striking given that these are essentially 2 polar opposite systems, where we would have expected them to have very different experiences. This is what they told us. We need to feel protected from financial harm. That's the compensation piece. We need information about what happened. This is a desperate need that patients and family members have, and they weren't receiving it, certainly in the US and often in New Zealand. So they want an honest account of what went wrong, including an admission of when the thing that went wrong constitutes an error, rather than just an unfortunate situation. They wanted to be heard. And we spent a great deal of time talking to them about what that meant to them. And again, the message is very, very consistent. They want to be able to narrate their own experience of injury and the impact that it's had on them to a provider who will look them in the eye, who will listen without interrupting, without taking notes in preparation for some kind of response, and without asking them to confine themselves to clinically relevant information. They wanted an authentic apology, which isn't always an apology of responsibility. It could, in some cases, when it's not due to an error, be an apology of sympathy, but some acknowledgement of the role that the hospital, the treating physicians have played in causing harm. And critically, they wanted to know what would be done to keep this from happening to another family. Sometimes this kind of accountability involves removing a provider from clinical care or taking action to curtail his or her scope of privileges. Not often, but sometimes. But often families here were much more interested in what the hospital was going to do in terms of putting new systems in place to prevent human errors from reaching patients and causing harm. And finally, many families spoke about their need to make meaning out of the event. This is kind of a wild card that expressed itself in all kinds of different ways, but they had a very deep need to feel that something good would come out of the event that gave them a sense of closure. So for example, one family that had lost a baby wanted to have a plaque with the baby's picture in the nursery so that the NICU staff would never forget what had happened in that case. Amerly wanted to be a teaching case at the hospital and in fact became one. Other families wanted a patient liaison established at the hospital to help families navigate situations like this. So again, a variety of forms, but all seeking to make meaning out of the event. What we didn't hear was a desire for retribution, vengeance, revenge, until the hospital had bungled the response. That's when the gloves come off. But this is not, it seems, a natural desire that patients experience to cause harm on top of harm. And that's why I think conventional accounts of accountability, or maybe the way we think as lawyers, especially as criminal lawyers, about accountability, doesn't attach well to this particular domain. It doesn't reflect patients' own emotional needs, nor, as I'll talk about, does it reflect the reality of how a lot of medical injuries happen. So these patient needs map in a loose way onto what tort scholars would call the three basic functions of our liability system. I'll use that for an organizing framework to now talk about the respective performance of these two systems and really delivering on this promise to patients. So let me start with compensation. This is my best attempt over many years to try to compile comparative data on compensation in our two countries. These data are actually really hard to find in New Zealand. I and others have spent a long time trying to compile them in the United States. But let me talk you through what I did find. Surprisingly, in both systems, the claiming rate among people who are eligible to get money, really low. For very different reasons, most likely. In the United States, the reasons are pretty clear. People don't know what happened. They don't realize they had a treatment injury and or can't get an attorney. And again, you just can't access this compensation system without one. In New Zealand, it's less clear. We know some characteristics of people who underclaim. They tend to be of non-Caucasian descent, for example. They have lower educational levels. But the story is less fully formed here. The two systems have very different mixes of injury in them. Mostly in ACC, they're dealing with relatively low severity injuries. In the United States, 85% of the people who file malpractice claims successfully have a permanent severe injury or have died. In terms of the payment rate, again, hard to get exact data from New Zealand. It pops around a little bit depending on what you look at. But it seems that between 45 and 63% of ACC claims get paid. Those that are denied are primarily because they don't meet one of these other little restrictions like causation. In the United States, our payment rate is higher, but keep in mind, this is already a very select group. It's already been vetted and screened and selected by plaintiffs' attorneys. So really what's striking is that it's not higher. These are cases that have been carefully vetted, and yet still 1 in 4 of these cases that in our research, when we look retrospectively at the whole litigation file, we said these guys definitely had a meritorious claim. 1 in 4 of those, they didn't get money. The payouts, very much higher in the United States than New Zealand. Again, it's hard to get a beat on exactly what the median payout is here, but it seems to be somewhere around $3,000 to $5,000. Maybe somebody in the room can give us an exact number later. And again, the United States, we're talking about paying non-economic damages, medical expenses, so very different sort of head of damages there. And finally, and maybe most strikingly, look at the median time to disposition of a claim. This is what we admire most about ACC. In the United States, it takes on average a year to file a malpractice claim. That's finding the attorney, working up the case, filing the papers, and then 2 more years to get that claim adjudicated or settled. Compare that to less than 2 months, even for complicated cases here. So there are some problems with compensation in both these systems, even though people in the United States love to complain about how expensive our system is and how liability is crushing physicians. In fact, they should be very grateful to the plaintiffs' bar, who insulate them from experiencing claims 97 out of 100 times that they commit negligence on average. So the biggest problem from a tort professor's perspective is not there's too much litigation, it's that it's too little, the system is too hard to access, it takes too long to get compensated. This gap in delivering equitable, swift, reliable justice is exactly what led Sir Owen Woodhouse to write that New Zealand had to move away from a fault-based system. And to reread that report today is to admire the prescience of that author in understanding the destructive power of the fault standard. All of the critiques could just as easily be made of the US system today. But it is defended on one basis by those who love it, and that is deterrence, or preventing injury, giving people the incentives they need to take care and not harm patients. I, again, have spent a lot of time as a scholar examining this evidence, and I haven't been able to come up with very much. Study after study fails to find an association between having more liability pressure in a healthcare setting and having safer care or higher quality care, no matter what the measure. There are anecdotes about where particular horrible cases have led to action, but at a population level, we just don't see this relationship. Why might that be? There are a bunch of pretty clear reasons. One is insurance. Health professionals are universally insured against liability quite generously. And for physicians who aren't part of hospitals, that insurance generally isn't experience rated, meaning if you have a claim, you don't pay more the next year. It's just hard actuarially for insurers to do that for a variety of reasons, so they mostly don't. You pay whatever everybody else in your specialty pays in your area, regardless of your experience. So that interrupts your incentives right there. And then physicians complain, look, I don't know what negligence means in a particular situation. You aren't giving me enough information to know how I should behave, except that I'm pretty sure I should do as much as I can to cover my butt in case something goes south here and this patient ends up suing me. So we have a lot of over-provision of care, but deterrence should be about connecting patients with the right care, clinically appropriate care, and it just doesn't seem to have that effect. So physicians hate being sued, not because they lose money, but because it's a horrible experience. They try to avoid it, but not in ways that necessarily benefit patients. In fact, in ways that can harm patients, because doing more things means more invasive procedures and especially more costs. Hospitals have clearer incentives in this system. Their insurance is experience rated. Some of them insure themselves, so they really do feel the bite. But the problem in my observation working with hospitals is that there are so many different financial incentives coming at them in the United States. These are mostly, if not formally for-profit organizations that are trying to make money and stay in business with thin margins. And they're being whipsawed by a lot of different forces in the market and from government using financial incentives to try to get them to change. And I just don't see much evidence that among all of these signals out there, they choose liability as a reliable and useful signal for where they should be devoting their quality efforts. Then you have a number of systemic problems with the way we process medical liability. We focus liability mostly on individuals. It's kind of hard to hold healthcare organizations liable. You can't hold them directly liable for the acts of physicians. We have this problem of imprecision in the system, where layered on top of all the meritorious claims are a bunch of claims that don't have merit. They get brought because people don't have the information that they need to make good decisions about whether to bring them. And about a quarter of the claims that we reviewed that we said, in retrospect, no merit here, they get money. So there's this very messy, noisy signal in the system. Then all of this creates an environment in which it's just very hard to make progress, as I said, on medical error reduction, because it's hard to get people to talk about things and be honest. It's hard to get people to report on their colleagues, to have open discussions about it, and to talk honestly with patients about what they could have done better. And finally, there's the other regulators on this slide of the fragmented regulatory system. We, again, don't do a very good job of policing competence. That is a nuclear weapon in the United States to take action against a physician's license, and it's reserved for very egregious offenses in the quality domain. And most of our other regulators of quality focus on healthcare organizations, not individual physicians. So we don't have a really robust analog to HDC that sort of systematically takes in complaints and acts on them in a consistent way. Okay, so I'd give us like a D, an American report card for how we deal with safety improvement. A D is very bad. Does New Zealand do any better? In preparing for this lecture, I actually kind of had a hard time answering that question. And again, I hope that some in the audience will help when we get to the Q&A. But it's pretty hard to find the kinds of studies here that have been done in the United States by independent researchers assessing the performance of some of these systems. HDC itself issued a very comprehensive report last year, but systematic evidence of how the HDC has impacted the quality and safety of medical care is pretty hard to find. Of course, with ACC having public financing, you don't have any kind of direct financial incentives for safety improvement here. On the other hand, you've got this no-fault standard, which can have potentially huge effects on cultures within healthcare organizations to really learn from error. The other major advantage that you have that I think people don't talk enough about is that all of the complaints go to one agency for the entire country, and all of the claims for treatment injury go to one agency, and they have information systems. They may not be cutting edge, but they have them. Whereas if I want to do research on treatment injuries in the United States, I have to go around with my hat in hand to potentially dozens of different insurance companies and get them to share information. There's no repository that enables that kind of analysis, so you can't be epidemiologic in your analysis. You can't look at the population level and say, where are things going wrong and why is that happening? I'm also impressed that you have agencies that actually have a specific statutory responsibility to improve safety and prevent injury in medical care. We don't really. Our medical councils have a related remit, but it's not as specific or injunctive as these statutes. And again, HCC has, to my way of thinking, a quite broad range of potential remedies available to it compared to any analogous organization in the United States. And of course, they are still operating on a fault-based standard. This is a parallel system. There's just a lot of different stuff they can do if they're concerned about a complaint. Moreover, they seem to be monitoring at least some of the outcomes when they do take action. For example, when they make recommendations back to healthcare organizations, they report that 91% of the time they get evidence that the organization complied. That's pretty amazing, if that's true. So overall, I think there's just very little doubt that structurally, New Zealand is set up way better to prevent treatment injuries. The structures, I think, are there. Nevertheless, of course, there have been concerns raised about how effectively these structures work. And in particular, I'm aware of criticisms of the HDC, focusing, for example, on the long time it takes them to resolve complaints. This is from their 2025 report. The stretch goal here is to have only 20% unanswered within a year. And again, if you think about what patients tell us about what they want to be heard. And so to have a complaint essentially go into a black hole for such a long time really cuts away at the sense of an accountable system. To their credit, though, they seem to be making quite good headway in reducing a large backlog of complaints. The report said that patients were very satisfied with the way the advocacy services worked with them in resolving some of their complaints, but was curiously silent about patient satisfaction with HDC itself, which seems an important metric of an agency's efficacy and the extent to which it builds public confidence and the sense of accountability. And then the chief complaint that I have heard from legal scholars is how few complaints result in investigations by HDC, just 1 in 20. About half are resolved without any action, closed without any action. About 1 in 4 are referred back to the provider that is being complained about for, as the report calls it, early resolution, but very unclear what happens when the complaint is merely sort of funneled back to the person that the patient obviously didn't feel comfortable approaching that complaint with in the first place. So I just have a lot of curiosity about the outcomes of these different types of complaints. Patients complain about a lot of things, and there are a lot of complaints that probably truly don't need anything more than a good hard look and a communication back that this was not appropriate for any action to be taken. But I would like to know much more about how the complaints that are chosen for investigation are selected. I'd love there to be more than one review of a file so that we know something about the reliability of decision-making about what should be investigated. And I'd love to know more about what happens when complaints are referred back to providers or referred out to other kinds of public agencies that are concerned with public safety. Finally, let me talk a little bit about corrective justice. This is an area where our system in the US does deliver in certain respects. Through a long process of legal discovery, you do certainly learn a lot about what happened in your care. You do, in theory, have this day in court where you get to be heard. You get to make the defendant sit there and listen to your story about how their negligence has ruined your life. And a surprising number of settlement agreements in medical malpractice cases, I've learned, contain specific commitments to improve safety. It's often the case that medical plaintiffs are willing to trade away a lot of money damages for these commitments. It's really important to them to get it right there in the settlement agreement. But there are other aspects of these psychological needs that our system just does not deliver. This information about what happened doesn't come at the point of care. In a lot of cases, it comes down the line through legal discovery. So it doesn't give patients what they are really looking for, which is a conversation where they look a person in the eye and hear them admit what happened and offer an apology. Settlement agreements never contain an apology or an admission of responsibility. And as for the stay in court, it almost never happens. Only 5% of malpractice claims are resolved with a trial. Most are resolved through these settlement agreements that are themselves confidential. Okay. The biggest problem, though, is that any of these benefits only accrue if you can get into the system in the first place. And again, here we're talking about 2 to 3% of all people who are injured by medical negligence. These quotes, I think, illustrate in patients' voices some of these failings. That they were treated shabbily in the immediate aftermath of the error, in part because of the fear that the system engenders. And they didn't feel that they were fairly dealt with in negotiations about compensation. And were not told if system improvements were being made. Of the 30 patients we interviewed, 24 said that the hospital never followed up with them to tell them what they had done to improve care. My impression is that experiences in New Zealand are more varied. Again, the structures are there. And so there's great potential to meet all of these expressed needs that patients have told us about. But the stories we heard suggest it doesn't always happen. On the one hand, we had a group of patients who had really moving stories to tell about reconciliation in the aftermath of a terrible event. And just as often, we heard stories like this. 73% of these patients from New Zealand said that they did not feel heard by their providers in the aftermath of an adverse event, which is, again, a bit of a puzzle to an American lawyer, given that you're operating in a no-fault system. So again, I think in New Zealand, the right structures are in place, but the execution doesn't happen consistently. And I'll conclude with just a couple of modest reflections about where things might go moving forward. As to the 2005 reforms, and this question of what might you have lost by removing the fault standard, my considered answer is not much. And one of the main reasons is that this standard is just a very awkward fit for all we have learned about how medical errors usually happen. Even when something can be called an error, it should not have happened in a good system of care. It's rarely because of a high degree of culpability on the part of the provider. Again, there are exceptions. There are frequent flyers in the malpractice system, for example, that probably shouldn't be practicing anymore. But the modal error occurs because poor systems interact with tired people who are being asked to do a lot with a little and who have lapses that cause harm. So a system based on the concept of moral culpability, to me, again, just doesn't reflect the reality of what we're dealing with. Further, I think it's important to acknowledge financial incentives do matter for healthcare organizations. They matter a lot in the US. But these 2005 reforms didn't change things in that regard. It was never the case that you had a private finance system here. So as long as the money comes out of the government pot, those incentives don't really make it through to healthcare organizations. A point I think is really important to take away is that if you were to return to a system where there was fault-based adjudications, you'd pay an enormous cost, a financial cost through protracted determinations, fighting among lawyers about who was or wasn't at fault. It's why it takes 2 years in the United States. And so a social cost, perhaps even more importantly. Again, driving learning about errors underground. And I think for that reason, I'm heartened to read that nobody out there wants to, in our esteemed president's words, make ACC great again by going back to the good old days where we toss around incriminating allegations. Yet, there is this inconsistency in action by HTC that I think it's possible may undercut some of the incentives that providers have to try to meet these psychological needs of patients. On the one hand, I've heard that they perceive HTC action as quite punitive. That might provoke the kind of cloaking behaviors that we see in our own fault-based system. And on the other, if they had knowledge that only 5% of the time does an investigation actually get conducted, they might feel free to do nothing at all to try to meet patients' needs. I don't know whether and to what extent these phenomena happen, but I'm curious as a researcher. I do think that additional sunlight into these processes would do a great deal to try to restore, improve public confidence in the system. And again, it's wonderful when agencies are self-reflective and issue extensive self-reports. It's even better when they invite independent researchers into their files to do a close look and understand things like how reliable is the decision-making and are they making decisions on the bases that patients would want them to be making. And finally, to the extent that they would like to be investigating more than 5%, is it because they have constrained capacities? It's really a question of funding and staff. The second major thing that I think could be done here is to take better advantage of the space that you have created in your system to try to offer strong resolutions to patients through their psychological needs. In any system, we can meet these needs, to be heard, to be listened to receive an authentic apology, to think outside the box about remedies. But they require particular skills in communication and emotional intelligence that I'm sorry to say not all physicians are born with. Some must be made. But striving to meet these needs, I think, really is critical in New Zealand as it is in the United States. Doing that should be a goal to which we all remain very committed. And I'll close with just one final thought from Amerlee that I think drives home the point that sometimes it's not about structures, it's just about people and their willingness to reach out and meet each other's needs. Through her recognition that treatment injuries can also take a toll on the professionals that caused them, this teenage girl showed the compassion and empathy that Sir Geoffrey Palmer spoke about so eloquently in his beautiful eulogy for Sir Owen Woodhouse. And he said, he believed those in distress should be helped, and the well-being of each should be of concern to all. Woodhouse, Palmer, Amerlee, I think all remind us of the moral imperative to continue working to make our social policy reflect that vision. Thank you so much. Very happy to take questions.